Hello, everyone. Let me center this a little bit more. Okay, there we go. Hello, everyone. I have an update here from the law offices of Andrew D. Myers, and we're gonna be talking about Karen Reed today. With that being said, sit back, enjoy, and hopefully you and I will learn a little bit more about this crazy case. Let's get into it.
With Karen Reed's retrial here now in the present, we join someone who should have been on the defense table, but they're here with us on our conference room table. Oh, and by the way, well, I am enjoying this nice, yummy matcha latte.
So, bad news for the Karen Reed team, but good news for us. I'm Lainey Law.
And I'm Attorney Andrew Myers.
And we have Mark Federer with us today. Hello, welcome back. We thought we weren't going to see you again, but...
Yeah, I thought I would be occupied for a couple of months and living amongst yourselves in Massachusetts, but alas, it wasn't meant to be, so here I am.
Well, I want to ask you about that, but first, just the day before we're recording this podcast, the Karen Reed team appellate staff filed an appeal to the United States Supreme Court. They filed a petition for certiorari, and people want to know what effect, if any, will this have on the trial? Will the Supreme Court even entertain this?
Well, statistically, these certiorari applications get granted at, I want to say, around 1%, or if even that much. So just as a matter of pure statistics, it's always unlikely. I mean, the U.S. Supreme Court can only hear so many cases that raise interesting issues. This certainly raises interesting issues. It's kind of unique in terms of double jeopardy, so maybe that has some interest. On the other hand, this has been rejected by every single court that's considered it rather quickly, whether we agree with it or not. And there's a trial that's ongoing right now, literally, as we speak. So, again, statistically, I think it's probably unlikely that cert gets granted. But, it is an interesting issue. It does raise real serious double jeopardy questions. But we'll have to wait and see.
Does it make any difference that, the trial is starting? I mean, they're right in the middle of jury selection as we speak. And also, it's a serious constitutional issue, double jeopardy. Does that push it up on the scale at all that someone at the Supreme Court would, take an expedited review, or not really?
I mean, I would think if they deem it a serious issue worthy of the court's attention, the schedule would come into play. I mean, ultimately, if the court were to hear this and determine that there should not be 2 of the 3 counts at trial because they were in fact acquitted, if that's ultimately what happened, that becomes very problematic when the retrial for those 2 counts is happening right now. And of course, if any decision were to come down after the case were heard, the concern that a court could have, number one, if there was a conviction for any count, it would have to be tossed out and we'd be right back to where we are. But the other concern would be if she were in fact acquitted on counts in 1 and 3, I mean, again, as some would say, with a jury literally saying the words not guilty, then the risk would be that this is moot. I mean, why would the court entertain this case where literally the outcome could have no impact if those counts are dismissed, unless the Supreme Court thinks that count 2 is an issue in the double jeopardy issue or not. So this is all kind of a mess. It is the kind of thing that if they were serious about hearing it, then they really should stay and stop the trial before jeopardy attaches, which happens when the first juror is sworn. And I know they're still doing jury selection, but my understanding is that none of these jurors have been sworn. I mean, in theory, she could have sworn the first juror, and that would attach jeopardy. But I can understand why the judge would not want to do that, to keep, legally speaking, Karen out of legal jeopardy until the last possible minute, just in case something were to happen.
I want to take a look at the petition just really briefly before we move on to other issues. So this is the actual petition in the Supreme Court, Karen Reed versus Norfolk County Superior Court, Andrea Campbell, Massachusetts Attorney General. Here are the two questions presented, and the reason I wanted to put this up on the screen is because, as we all know, it takes forever for the Supreme Court to hear something. If you file, especially if you're on the civil side, but that's not pertinent today, if you file a petition certiorari with the U.S. Supreme Court, it's going to take months before they even decide whether they're going to hear it or not. But in fact, if there's a guy on death row, take that up right away. So I'm wondering where in the scale this is, where the two issues presented in the Karen Reed petition are: one, whether a final and unanimous but unannounced decision by a jury following trial that the prosecution failed to prove a defendant guilty of a charged offense constitutes an acquittal, precluding retrial under the double jeopardy clause. And then the second issue that's couched, and knowing how to phrase these issues is the key, is whether a defendant who produces credible evidence of such a final, unanimous, and unannounced acquittal is entitled to a post-trial hearing to substantiate the fact of such acquittal. My question to you is, do either of those issues rise to the level of having the Supreme Court expedite their deciding whether they're going to hear it or not?
Well, I mean, you're talking about a defendant who was tried for murder, who is alleging that they were in fact acquitted, which there has been much public statement by several of the jurors that she was in fact acquitted. For reasons that are still mysterious, the jurors, if that was their view, never actually published any acquittals. There's been interviews. This is not evidence in court, obviously, but there's been interviews with at least, I think, one juror who said we had questions, but the foreperson didn't want us to ask. All kinds of disturbing things. I mean, but is this the kind of thing that a court ought to hear before someone is potentially retried and has been allegedly acquitted for murder and is in jeopardy again and could be convicted of murder? That's tough. I mean, if you believe in the American sense of fairness, due process, the right to a fair trial, the Bill of Rights, and anything else you can come up with that, the same idea, then it is the kind of thing that ultimately could be expedited. But again, they are literally on trial as we speak, and if something is going to be done, I think it would be critical that it occur before jeopardy attaches, because if the Supreme Court were to intervene in any capacity after jeopardy has attached, then you have another mistrial, and it leads to all complicated arguments again going forward as to who's at fault and whether there was a manifest necessity and all of that kind of stuff. So it's messy, and if it's going to be dealt with, it ought to be dealt with before a retrial. I think that the part that has never made much sense to me relates to the second question presented, which is this kind of always screamed out for an evidentiary hearing to bring the jurors in, not to go, not to look under the kimono and ask, tell us what you talked about, tell us how you got here, just really confirm two critical questions. Number one, did you all agree to an acquittal on those two counts? And it's important to establish as if you were done deliberating, like that was a final decision by all 12 of you. And of course, if one person said no, that's the end of this. I mean, this would be over. But the next question, I think, which is always really begged to be asked, and I would have liked to have seen the trial court entertain this, would be, assuming the first question is yes, we had 12 unanimous jurors reach a final decision of acquittal on both of those counts, it kind of begs the obvious question, why the hell didn't anybody tell me, meaning the judge? And I think that's a very fair question to get from, we all meant to acquit, but we didn't do what juries who reach verdicts traditionally do, which is say guilty or not guilty. And again, you've heard at least one juror talk about it. You've heard 5 or 6, however many, talk about we did reach an acquittal. We thought it was this. We didn't understand. And it is disturbing that everyone just appears, everyone with a robe on anyway, appears to be not concerned with that, because there is no prior controlling precedent on this type of issue as it relates to double jeopardy. And I would think that this is something that should be clarified, not just in Massachusetts, but it's a federal right. I mean, obviously, it's in the Bill of Rights, the right against being tried twice for the same crime. So, I mean, there's certainly federal jurisdiction, and there ought to be, I'd like to think, some clarifying principle about when someone is acquitted, although I don't know if, again, because of the timeline and issues here, that this is going to be the case. It's still a long shot.
Yeah. So now, as we are doing this podcast, the court in Norfolk County, of Massachusetts, is doing jury selection. In our last podcast, we were following people who were saying it's going to take an awful long time to impanel a jury because the case has been so upfront in the media, on podcasts, on the newspapers, because there's been so much publicity. It could take an awfully long time. People were saying, I was listening to a radio host in Boston by the name of Grace, who said, she put out a poll, and her listeners were saying it could take 3 weeks, it could take 4 weeks. Here we are, only 4 days into jury selection. As we just checked before we went on, they've already selected 10 jurors in 4 days. My question to you is, do you think the fact that this is going so quickly might bode ill for this trial? Are there people that just don't want to admit their biases and opinions because they just want to get on the jury? Do you think that might be happening? I do.
I find all of the jury selection process in this particular case troubling and not open, frankly. Obviously the public is not witnessing or hearing how the jury is being selected, what the questions are. Everything's done at sidebar, as is the way in that court. But even more troubling is this process of, one juror at a time, rather than a panel, a veneer, as we call it, fill in the box and beyond, and having the opportunity for the lawyers to ask their own questions, to preview the issues that they see in the case, to engage with a juror, take that answer, present it to another juror, start a dialogue, start a conversation, and get a real chance to see how these people interact with other people, how they interact with each other. I mean, that's usually, certainly in a state court murder case, how jury selection is done. In this particular case, everything is done privately, everything is done at the bench, everything is one-on-one, and we have no idea whether anyone's making cause challenges that seem legit, or whether the judge is taking an aggressive view and daring you to waste peremptory challenges, and are the parties just getting stuck with jurors that the court has refused to strike for cause, and they just want to bank any peremptories for what's coming down the line. The other problem I have with the way they're doing jury selection, by not having a full panel and not knowing who's necessarily up next, and seeing the list down the line of the 10, 12, 20, however many people are in the panel, that can greatly impact your strategy, as you know, in terms of when to use a peremptory, that I don't want to burn them on these two because I'm going to need it for these three in the back based on what's happening. And to me, just this whole process of jury selection in a case like this, with these issues, depriving the lawyers of doing it, depriving the public of seeing it, not knowing what's going on, the fact that, as you said, they end up picking 10 jurors within a couple of days, 3 or 4 days, that would worry me a lot.
I think it worries a lot of people. Most attorneys prefer attorney-conducted voir dire. In other words, we're allowed to go up and we ask the questions because there's more of an interaction. You can see people's responses and see if they're paying attention or not. This is judge-conducted voir dire, which most attorneys...
I wouldn't even say most. If you can find me anyone who's tried cases who would prefer to just basically sit there and twiddle their thumbs and take note while the judge does jury selection, I'd like to meet them, because it'd be the first time I've ever met anyone who's tried cases that would want that. There are so many critical reasons why any trial lawyer wants to get deep into the weeds of voir dire. It can be as critical as any other part of the trial. It's a chance for the lawyer to connect with jurors, potential jurors, to see who may get along with others, who may not. If you if you are allowed to ask your own questions, you're obviously raising issues that are of your unique concern to the case, that you're trying to see how people might react to that. You're trying to see reactions of other people. You're being deprived of that. You're being deprived of just connecting. You're being deprived of essentially everything. And unfortunately, it's just, in this particular courtroom, it's the way things are done. All the sausage is made in sidebar in this case for some reason. And to do that to these lawyers on both sides, frankly, this is not a prosecution or defense thing, but to do that in a case like that, to have the judge literally, run point on asking the jurors all the questions, it's just, I don't know a single lawyer who would ever say this is the right way to do it.
No, I don't either. Before we get into other issues, and there are a lot of them right now, I have to ask you about your petition to join the team here in your petition pro hoc vice, and the judge rejected it, as everybody knows, on the basis of the conflict issue. I looked at that rule. I fully agreed with you, and not just because you're a guest here and we like having you. I fully agree that, when there are conflicts, some are waivable, and I fully agree, looking at the rule, that this was a waivable conflict. You've addressed that elsewhere. You were very thorough in addressing that. Do you think that the court in this case, simply used that as an out to just get you off the defense?
I mean, I'll let others answer that part of the question. What I'll simply say is this. I've been doing this 26 years, very ethically at a high level, with a very solid reputation, no ethical issues or any concerns. Obviously, when approached to get involved in this case, any lawyer would recognize what I will call the possible conflict of interest. I'm not even prepared to say that it's an actual and waivable, but certainly any lawyer would recognize that there is a possible conflict of interest because of just the overlap, if you will, and that was dealt with in a way that you would expect anyone who's understand what the rules of professional conduct in any state to do, to address that with both clients, to make sure that they consult their own attorneys outside of your presence so that they can freely agree or disagree or raise any concerns, execute what you call informed waivers and lay out in excruciating detail any possible or actual conflicts and what that means and how it could impact one or both of you, and what's waivable and what that means and what's not waivable, and all of that was certainly done. All I's were dotted, all T's were crossed, all the appropriate ethical rules were presented to both clients and their lawyers. In the petition or affidavit that was submitted seeking my admission on behalf of Karen, it was noted that to the extent questions about any possible conflict or waiver issues or what could come up, that I had agreed to speak to the court ex parte, which I would have done, and instead it was just denied out of hand on what she determined was an actual and non-waivable conflict. I mean, look, she's the judge. I'm just a guest here. I'm not even admitted in the state, so I don't really, it's not for me to do or say what happens or what should have happened, other than I think she was wrong, period. But ultimately, it doesn't matter what I think. It's not for me to decide.
One more question on this before we move on. One of our commenters here on this podcaster said Attorney Mark Betterow can do more damage to the Commonwealth. This is their words, not mine. Attorney Mark Betterow can do more damage to the Commonwealth not being on the Karen Read case. Judge Cannoni can't put a gag order on him now, and if Attorney Betterow is human, I'm sure he has thoughts about Attorney Brennan and the judge for denying him to participate in the Karen Read defense team. What would you say to our commenter?
Well, again, I would much rather do damage as being part of the team and, sharing my view in a courtroom of what I think is just not a great criminal case, one that shouldn't be brought and whatnot. So I'm not able to do that. As far as my opinions of the judge and the prosecutor, look, I think the judge was wrong. I mean, that's what else can I say? I think her ruling was flawed. I think it was wrong. But beyond that, she's the judge. I respect that. You know, as I said, I'm a guest here. I have no real
I'll be
say in
right
the matter. That's all I'll say about that. As far as Brennan, I think what he did in his non-objection, if you can call it that, was disgraceful. Disgraceful for the simple reason that if you're going to smear my ethics or make claims that I am somehow acting as a vessel or implying that my role is to be a vessel of communication between two clients in which you think there's a conflict, then present some damn proof. Those allegations are false. And if they weren't made in a courtroom, they could be actionable. That's how offensive I thought that was. And to me, it goes hand in hand with a pattern, I think, of sloppy, misguided, inaccurate, frivolous, deliberately false, any other words that you can come up with statements that he's made in the past. So I think it's regrettable, and I think he ought to do better than, or at least have the guts to say, I object. He shouldn't be here because I'm accusing him of things. And ultimately, I think it's unfortunate that, in responding to some of those in the supplemental affidavit that was submitted, that at a minimum, the judge didn't take the opportunity, again, ex parte, to say, to the extent I have any concerns about what's being raised, I'll give you an opportunity to be heard. And she didn't.
One of the things I found really, I'm struggling to find the right word, but denial by the court of defense expert Mark Easter, a retired FBI crime scene expert, to testify regarding standard investigative policies and procedures in crime scene handling, and saying it's within the common knowledge of a layperson. In your experience as both a prosecutor and a defense attorney, as you just pointed out, for decades, have you found that crime scene integrity is in the common experience of lay people?
Unless you're counting watching CSI Miami and shows like that as somehow making laypersons expert. No, I thought that ruling was flawed on its face for a couple of reasons. I mean, it's true in the first instance that it's not that common that either party will call an expert on crime scene issues. However, in this case, it's a key and central component of the defense. We believe she was framed, that they destroyed the crime scene, they didn't do things, they deliberately ignored this, or even if it was just plain incompetence, it deprived them from doing a real investigation. So that clearly is relevant. Then what's interesting is, in denying the FBI agent, I thought, if anything, she would focus on wrong guy, right idea, meaning it was a little surprising to me that the sought-after expert was an FBI agent, only for the sense it was unclear how much actual responding to active crime scenes did he do. I don't know the answer to that, but obviously FBI agents are not as frequent in doing that as you will find, people in the Canton Police Department, the Massachusetts State Police, who do that on a day-to-day basis. But instead, our focus was entirely on what you can do is just vigorously cross-examine. Lay people will get it, and the idea that lay persons understand all of this about why a crime scene has to be secured, why a chain of custody is important, why preserving evidence is important, why, for example, when they're doing a search later that night, that they use the wrong team. They use this CERT team rather than the crime scene unit, who literally documents their own recovery, vouchers their own evidence, photographs it, as opposed to the way they did it. I mean, you could go on and on with the things, and you saw some of this even in the Canton audit. Why witnesses have to be separated, why they should be videotaped or recorded if they're willing, why they should be interviewed in a precinct rather than in the comfort of their own home with someone else sitting in the other room. I mean, you could go on and on and on and explain why lay persons may not understand this. And the real harm here to the defense is they can establish all these points, but if they have recalcitrant witnesses or just people that are going to argue with them on the stand as police officers and say, well, I'm not sure I agree. Now you're putting the defense in a position of having to argue, badger, be argumentative. Jury thinks they're coming from a position of weakness. They look desperate. Maybe this witness is accurate, when all you had to do was have someone like Easter or whoever get up and say, listen, this is what we do and how they're trained. What the defense is going to have to do now is obviously spend a lot of time on these police officers, what training they received, how they were trained in crime scene preservation, how they were trained in doing X, Y, and Z, and then basically dragging it out of them that you were trained to do this and you didn't do it, and just leave it at that and then argue to the jury.
Yeah, before I went to law school, I spent 10 years as a reporter, and I observed some pretty grisly scenes. And even I know that, you seal the thing off, I don't care if it's a blizzard. That's number one. I've observed them go into a home with their booties and their gloves and their Tyvek suits. I've observed them in a backyard as though it's an architectural site, going, not even inch by inch, but micrometer by micrometer, digging down. Right. I've seen all this, and even I know, having also tried cases as an attorney, I don't know what those procedures are. They learn it, and so it seemed to me a huge blow to the defense to not let an expert who knows this stuff. I mean,
facts.
I have some experience, but I don't know it, and I don't think a layperson knows it either. So I think that decision was clearly wrong. But the question I have for you about all that is, judges have wide latitude of discretion in determining whether or not an expert is allowed. Is this an appellate issue? Be appealed now, interlocutory?
No.
Anything?
No.
A serious appellate issue later?
I mean, anything that has judicial discretion is clearly hard. You would need an abuse of discretion. It seems to me that it could be perhaps, if there is an appeal after a conviction, which I don't think is likely for other reasons, but if there was in fact an appeal, one of the issues that I think you would have is a very, what I'll call a macro, broad stroke, Sixth Amendment due process right to present a defense claim, and that the judge, through just repeated actions such as this, such as denying other, defense motions to exclude what appear to be unqualified experts, the third party culprit that she's not allowing, that she just, every time there seems to be some sort of discretion, most judges will err on the side of the party that has a constitutional right to a fair trial if it's a close call. I mean, that seems to usually be the way. In this particular case, that's not the case at all. A lot of these discretionary, if not all of them or most of them, these types of rulings are all skewing away where you would expect, look, I'm going to let them do it, whatever weight it is, I'll let the jury decide. I mean, it's the same thing with the third-party culprit thing. To issue an opinion that denies them outright the access on one and says, I may allow you to do it with the other two, but I want to tell you that the evidence is it's really thin and barely minimal. I mean, those kind of words in the opinion itself are gratuitous and serve no purpose other than being reported in the news. I mean, if you're going to allow it, you allow it and let the jury determine how it's strong or weak. If there's enough evidence to allow it, just allow it. There's no need to opine from the bench that, this really isn't that persuasive. So I don't think it's appealable on its own, but when there is a pattern of discretionary rulings that all appear to skew away from the defense and their right to present a defense, then, that becomes, I think, an interesting issue if there is an appeal for an appellate lawyer to at least consider.
Something interesting that came out in the last week before we recorded this issue is the audit of the Canton Police Department, which raised some very serious issues. First of all, police failed to photograph John O'Keefe's body where it lay. Witness statements should have been taken at the police department, not the scene. The witnesses should not have been together. This is really basic stuff, as you pointed out before. A CSI casual observer would know you put them in separate rooms. Both Canton and state police should have maintained presence at the crime scene until everything was taken a look at and collected. The surveillance videos inside the Canton Police Department of the murder weapon, the car, the judge is just clearly wrong by saying, "Oh, how could they know?" That should have been preserved. So it goes a lot deeper than that, but just for our purposes, let me ask you two questions. One, your thoughts on the audit itself, and two, do the findings of this audit of the Canton Police Department get admitted into the trial?
So as far as the audit itself, I mean, what do you expect? I mean, the Canton Police performance as it relates to the investigation back in January of 2022 was a joke. I mean, I don't think anybody with a straight face,
that investigation was sloppy as hell.
The analysis, whether you're pro-police or not, would say
sloppy
that
investigation.
The way the Canton Police Department conducted itself in the investigation of, by the way, a fellow police officer and town resident, okay, was done in any form of professional way. As far as whether the report is admissible, no. But what the report does is it gives bullet points to the defense to add to the questions, just in getting to the fact that they didn't do an appropriate investigation and do things, but they're not going to be able to elude.
They didn't even
fact
try
that
to do an
some
appropriate
independent auditor
investigation.
Came out here and agreed that this was done poorly. I think for the defense, it's really a larger issue, which is they're going to have the benefit of arguing something that is virtually unprecedented in any case, even where defendants argue that the police investigation was either corrupt, incompetent, whatever you want to call it. They get a double whammy. I mean, you have in this case, and to my recollection, I've never seen this before, two separate police agencies completely and utterly screwed the pooch on this, and it was either incompetent and or worse. It's bad enough that you have one, like say the Canton Police, who did what they did, but that was followed up by an even, perhaps some would say more pathetic performance by Michael Proctor and his people in the state police with the way they conducted the investigation. So, two agencies are going to be under attack for separately doing atrocious work. I mean, that's certainly very favorable to the defense, particularly where the lead investigator, as awful as he was the first go around, has since been terminated, and if that's not bad enough, was terminated, at least for one of his specifications, literally for exhibiting bias against this defendant on trial.
Yeah.
I mean, that is, that's not good.
Can't the defense attorneys find the educational materials that the police officers, whether it's the Massachusetts State or the Canton locals, used? Can't they find the materials that were taught to them in the academy and point out, you went to the academy, didn't you? You graduated in such and such, didn't you? Didn't you use a manual? Yes. Isn't this the manual? Yes. And then turn to the page that brings up all these points and say, it says you did this, but you didn't, did you? Can't they use that as a technique?
I would hope they would. I mean, again, the Canton Police Department is, obviously a relatively, on my experience, small. I mean, I'm used to dealing with the NYPD, which is like 45,000 cops. But I'm sure they have something, and certainly the Massachusetts State Police do. So really all you need to do is find whatever versions of their rules, regulations, manual were in effect at that time. You can't use something from, that changed from the audit. That would be, but you find what's in use at that time, and you do all that. I mean, in New York, they have what they call the NYPD Patrol Guide, and it's thousands of pages of every single thing, whether it relates to an arrest, physical appearance, you name it, what a police officer is supposed to do in every situation. And we use that all the time to go over. And if they are, are you familiar with regulation so-and-so? And you hope that they are. And if they're not, you show it to them. They acknowledge that was the regulation. That's what was in existence at the time. They're going to obviously agree with you what the regulation was. And then you bring it to the facts of this case where if they didn't do it, and then it speaks for itself. I would hope they would do that. I don't think they did that the first time around, but given the nature of the defense, I'd like to think that would happen this time around for sure.
Another podcaster had brought out some materials earlier this week, and I've got to look into those. I know I've been in litigation with the MBTA, the Mass Bay Transit Authority, and they have a huge manual similar to the one you're talking about in New York. And
Something.
yeah, they do. And back when I did OUI defense, drunk driving defense, the National Transportation Safety Board has standards and policies that change every year. So don't make the mistake I did of using the wrong year. You got to find but once you find the correct year, it's good cross-examination.
Yeah.
Exactly.
I want to change the subject a little bit, and I know there's certain things you can talk about, and there's certain things you can't talk about. So I respect that. But tell us what you can. About Aidan Kearney. Witnesses are generally sequestered out of the courtroom before they testify. And Aidan Kearney, I'm sorry I mispronounced the name, and I'm called on the carpet for that all the time. He has been placed on the witness list by Special Prosecutor Hank Brennan. Do you see this clearly as an attempt by Mr. Brennan to keep Turtle Boy from covering the trial? And B, tell us if you can about your motion to allow him to cover the Reed trial.
Well, the answer to the question is, of course, we view it as a stunt to keep him from covering the trial and being there. And, it's a double whammy again. I mean, it's not just that he can't be there, but if he were to be sequestered, then he couldn't cover it on his show or his, the blogs and written entries that he makes. And, that's his livelihood. So you would be literally forcing him from his livelihood because he is on the prosecution witness list as, in theory, a rebuttal witness, as they've said. They've acknowledged that they don't intend to seek any of this so-called consciousness of guilt evidence of Karen Reed, by the way, not him, obviously, unless the defense were to somehow open the door on cross-examination, and therefore he needs to be a witness. We need to look at his phones. We need to see all this. He needs to be sequestered because if it turns out that, him and Karen Reed had any communications and then he went and approached some witnesses, obviously that would demonstrate Karen Reed's consciousness of guilt. I mean, in the first instance, that's a hell of a stretch. And for that reason alone, a court should deem that inadmissible, that's just a bridge too far at a trial of Karen Reed to suggest that if you're doing this and communicating with her, that somehow evinces her consciousness of guilt. And as a judge, and I said this during the first trial when this happened, when some of this even came out, that's going to get flagged for appellate review as well in the event that there was any conviction. So yeah, we think it's a stunt, but the other thing is this: it's not the first time that this has been done or sought by Brennan. He did it in the Bulger case. Now, from the other side, obviously, he tried to kick out, Howie Carr, a couple of other journalists who one might imagine and can understand were very critical of Whitey Bulger, because Whitey Bulger was a gang boss who had people murdered and committed crimes for 30 years and was half an informant, not a very good one, and disappeared for all those years and was just not a very likable guy. I mean, people get it that obviously the Boston Herald and other entities are going to not endorse that, and they were put on the witness list by the defense in that case, and they were sought to be sequestered. And really, it's similar to what you see here. It's a way to silence journalism. Now with Aidan, that's been going on for the better part of a year and a half, and they have been trying to silence him any way imaginable. So you've seen this before. The First Amendment there's a reason why freedom of the press, freedom to speak, freedom, access to trials and information is number one. I mean, there is a reason that the founding fathers made that numero uno, and certainly it's our expectation that to the extent that they would try to silence him because they deem him to be a material witness, I think that would be very dangerous to his First Amendment right to cover the trial. And you have to also remember, other journalists have been allowed in the courtroom who are on the prosecution witness list, Gretchen Voss, by example. There have been exceptions for other witnesses, understandably so. I mean, the O'Keefes, obviously, they should be able to see the trial of their loved one, trying to attempt to solve what happened to him. I think most normal, rational people would say the idea, because they could be witnesses of some nature, keeping them out of the courtroom would be unconscionable. Same thing with Karen's parents, to the extent they're on the list. How can you keep them out? So, you can't make a Turtle Boy exception. Turtle bad, therefore no First Amendment. It is a dangerous road to go down in access to reporting and just giving updates on what's happening.
Well, do you think your motion will be heard in time for the trial to start?
Yes.
Okay. All right. Lainey, chime in here. I have more questions, but chime right in anytime.
Oh my goodness, I get sucked into listening to you guys talk. You actually talked a lot about something that I was curious about before, because we were talking earlier about just like the crime scene investigation being obvious to like any layman, and even just like failing to photograph the body. It's just like, I wonder almost how the defense can use that. It's like, if it's supposed to be common knowledge that they're supposed to know what the investigation is going to be like, they should know you should get a picture of the body when they find it in the state that they find it. But
No, it's definitely not common knowledge, for the simple reason, when they found John O'Keefe, I mean, he clearly was in steep decline and probably beyond saving at that point, but he was clinically alive.
due to the cold.
At that time. So I don't know that it's obvious to lay people that if somebody is literally not dead, that somebody should be out there taking pictures and doing stuff and whatnot. But that's even just one example about what the cops should be doing and having expertise. I mean, you have or will have testimony in the case, presumably, that during this period that Karen, in an emotional state, is running around the way they're describing it, like a lunatic, screaming, "I hit him, I hit him, I hit him." Somebody's job in the police department at that point would have been to attempt to determine what that means. I mean, they're not supposed to avert their eyes to potential criminal activities or explanations of what's happening just because, there's something crazy going on. So the fact that no police officer even said, "Ma'am, come over here, calm down, I know you're upset. What do you mean you hit him?" I mean, that could have meant in the back of the head with a baseball bat. That could have meant a car. It could have meant a number of things. Also, if they ask, "What did you do?" that would help determine medical issue. Because one of the other problems is all of the EMTs and cops who testified, at least for the first few critical minutes, I don't think it would have made a difference, but I'm not a doctor, were unaware of what really is the catastrophic injury in all this, the blow to the back of his head. If they had said to someone, "What do you mean you hit him?" And again, hypothetically, if somebody were to say, "Well, I hit him in the back of the head with a bat," that's also important for the medical personnel to know, so they know what they're dealing with or not dealing with. So, I mean, you could go on and on with 27 examples of what seasoned professional investigators should have done, they didn't do, and why lay persons would not necessarily just know that. And I think for a judge to just assume that they'll know and you can cross-examine and we're good here, I think that's just an atrocious ruling.
Well, it sure is.
Now, I want to ask another question real quick, because you guys were talking about taking Aiden and taking his phone and all of that stuff. Do you think that there's any chance that that's actually going to happen? Because I was actually really shocked when the defense was like, "Oh yeah, Karen Reed gave up her right to attorney-client confidentiality by talking about it in the interview." So obviously we're glad that got rejected, but at the same time, is there any chance, do you think, that they might get him in on this?
No, I don't. Because the other thing is this, okay, they have told us again and again that they need to have him testify to establish, Karen Reed's consciousness of guilt. At the same time, they have told us again and again that means that he himself is guilty and has been conspiring with her, and that whatever he says or did is also incriminating to him. Okay? He also is awaiting trial for the same set of facts. Okay? So what attorney in good faith in these circumstances would not, on behalf of their client, say, guess what? If that's what your intent is, then he intends to assert on the advice of counsel his Fifth Amendment right, as any lawyer would do, okay? Any lawyer who wouldn't do that probably should check their malpractice insurance in advance, make sure you're in good stead, and then just say, have at them. So the reality is, because of the way that they are coming after him and the way they are telling us that this is all incriminating, by telling the court now, if they do that he's going to assert his Fifth Amendment right, then they can't call him as a witness anyway. If you accept that fact, then why the hell can't you be in the courtroom covering the case as a journalist?
I want to ask you about third-party culprit. We have to ask now the evidence with regard to Brian Higgins and Brian Albert will be allowed, but Colin Albert will not be allowed. They may not mention it, the attorneys, in their opening arguments, but they can develop evidence as they see fit during the trial. What's your take on all of that?
I mean, again, I think the ruling itself is wrong in the sense that, as it relates to Colin Albert, that the court seemed to credit facts that are actually highly disputed to justify where his presence may or may not have been, and other issues related to him. I think that the defense made enough showing to allow them, if they see fit, to make that argument. Now, one could argue it's not that great evidence, and it may not even help them to go down that rabbit hole. But I think it's not for the judge to decide whether they should or shouldn't. I mean, the reality is, you know, there are screenshots of text messages which allegedly establish his alibi, but they're not like true phone records. And there's been some discussion on whether how accurate that was or was not. There is evidence that he was in the house, although the witnesses in the house put it at a different timeline. That's true. But there is also evidence that, for whatever reason, Colin's mere presence in any of this was just whitewashed by the police.
It
For the
was.
better part of 7 or 8 months, whatever the timeline was, until the defense started their argument that something terrible happened in the house as being the cause of this. He testified that, you know, he never gets in fights, and you know, obviously everyone knows about the videos of him threatening people, and, you know, all these just idiotic videos, whether they are what they are. You know, he's never been in fights. There was also testimony right after this time period that he had, you know, scuffed knuckles across his, I believe, his main hand, which would be your punching hand, which is evidence of something. And his explanation was something along the lines of, I slipped on ice and fell down by, instead of, I mean, I would suggest to you it's an innate reaction. Any human being would be likely, I mean, it's not even something you think about, but, you know, he's thinking about this.
Yeah.
So would people credit that testimony, or do they? I think that's highly doubtful. Having said all of that, to me, you know, third-party culprit, it's kind of a, it doesn't matter. It's just kind of a word, a term of art. The reality is their defense is, I didn't hit him with a car. And, you know, we have expert testimony from engineers and experts to establish that. And by definition, that leads to, if she didn't do that, somebody else did. And that also means that if she didn't cause that accident, that the taillight pieces that were found had to have gotten there from another source in a natural way. And that really dovetails nicely into this, you know, we blame the cops defense, if you will. So, you know, could they say these people had motives? You know, Higgins was doing weird stuff in the bar, sending weird text messages, jilted flirtation, didn't end well. You know, the butt dials between all of them. And I mean, I think you can still do all that and say, look, it's weird, okay? But I think what I would say, rather than pin it on them literally, is say, you know, you don't necessarily have to find evidence of who did this. And, you know, in all fairness, we don't know who did, but we know damn well who didn't, and that's her sitting right there, based on X, Y, and Z, and sprinkle it with constant references to reasonable doubt, and then I think you pack up your bag, you go home, it's an acquittal.
Yeah, it's got to be a focus on reasonable doubt. It's got to be a focus, and it's got to be a better, I would think, jury instruction on reasonable doubt. It's got to be a much better jury instruction. I've got a lot of questions for you, but I'm going to hone it down to one. I've never heard of a former juror in a case jumping out of the jury box and then becoming an attorney. So what are your thoughts on Victoria Brophy George, who was in the jury the first time around in the Karen Read case? Of course, she was made an alternate, so she wasn't a deliberating juror. Turns out she's an attorney. Turns out she's now working for David Yanetti's office. So I've never heard of anything like that. Have you? That's the first part of the question. The second part of the question, what do you think her role will be? Is it a threat to the judge that a juror is now defending?
Well, in the first instance, of course not. I've never heard of anything like this. No one has ever heard of anything like this. This case is full of what's going on here. I mean, that's certainly maybe tops on that list of, wow, that's just stunning beyond belief. So obviously you'd have to leave it to the people involved as to how that came to be and, you know, its purpose and whatnot. Is that the kind of thing that gets noticed by the judge? Of course. I mean, do I think it matters to the judge? No, I don't think it serves anything. In terms of what does it mean to the overall case, and you know, you have to be delicate when you say this, but I don't think it has any real impact whatsoever, just for the simple reason it can't possibly be that she was brought in, and this is no fault of her own, but it can't possibly be that, you know, a relatively young attorney who's been even out of practice for a period of time